Well, it's really good to be here. And when I say that, I really mean it. That has taken on a new meaning for me. A couple of months ago in June, I woke up one Saturday morning, had a little bit of a tickle in my throat, and I went rapidly downhill from there. Ended up testing positive for COVID as well as my 2 millennial children. So we all spent 2 weeks in quarantine in my home, and that was a great time. But I have to say, it was a beast, but I did recover. It took me a lot longer than it took them to recover, but I recognize that I'm fortunate, you know, and a lot of you probably have been ill as well, or you've had friends or family members that have been sick, and it's been a tough time for everybody. So as I was thinking about this, I was like, well, you know, what can groundwater districts do to make things better for people during this time? And really the biggest thing is just being transparent. And so that's the title of my presentation, is being transparent during COVID, or I like to say, not hiding behind the mask. So what I'm going to be talking about today is just some things that you might already be doing. We've already had to change the way we do business based on this pandemic. But there's some things I want to go over that maybe you haven't thought of, or, you know, we may be in this for a while. So it's good to be reminded of the suspensions that have happened that have changed the way you're doing your business. First, I'm going to talk about the Open Meetings Act, and Governor Abbott, as you know, has suspended some provisions of the act that affect how you handle your meetings. You know, normally under Open Meetings Act, you can have a part of your board can be in a video conference, and part of them can be present at the physical location. As long as you have a quorum physically, then that's okay. Well, that's changed now with these suspensions, where you can actually just have a virtual quorum and you're good to go. So let's talk about some of these, the effect of these suspensions. First of all, it allows governmental bodies to conduct meetings by phone or video conference. It suspends the requirement to have a physical location where the public can gather, and suspends the requirement for a physically present quorum. So, as I just said, you don't have to have a physically present quorum, but you still have to have a virtual quorum. So one thing I wanted to mention on this is, during the last session, House Bill 2840 amended the Open Meetings Act to give the public the right to provide comment on an agenda item. And hopefully most of you have already adjusted your bylaws or whatever, and you're doing that in your meetings. Well, this suspensions that went into effect in March, that provision was one of the ones that was technically suspended. And so I think that was because it could be interpreted to read that a face-to-face meeting is required, and so they suspended it. However, it doesn't mean that you suspend public comment, especially since the requirement is that whatever audio or video system that you're providing, you have to allow for two-way communication. So I just want to point that out, because I've seen a few things on that, and I definitely would not want to take the risk, you know, and say, well, you know, it's suspended, we don't have to allow public comment. You need to do whatever you can to help people, you know, be part of these meetings and be able to participate. One of the other things that I would suggest is, if it helps for you to anticipate how many people might want to present comment, you can ask people to register online in advance of the meeting, and that's perfectly fine. Or you can provide a way for them to submit written comments through online or mailing in. And especially if, for some reason, if you're having technical issues with your video conferencing, just make sure that you're providing some way for people to comment on agenda items. So this slide shows you just a sample of a notice. In this particular case, I combined an in-person and a remote meeting notice. You may be doing totally in person, you may be doing totally virtual, but if you're doing virtual at all, you need to have certain elements in your notice. It doesn't have to be posted physically. This can all be online, but you have to include the toll-free dial-in number for the phone or video conference link, and it has to be audible to the public and allow for two-way communication. Also, you have to include your electronic agenda packet in this notice. So I would just suggest that after the presentation, you take a look at this and just compare it to what you have. Make sure that you've included all these elements so you don't get tripped up on notice issues. Just want to mention for board members especially, as I said a minute ago, face-to-face interaction is not required now, but you still have to offer alternative methods of communication to the public. And that would be, again, through allowing public comment. You also have to provide the public with access to recording of your meetings. So you can do that by posting it online, or if someone requests it, make that available to them. Also want to mention that none of these suspensions affect the 72-hour notice requirement that is standard for your board meetings, and it doesn't affect emergency meeting notice requirements. So if there's another hurricane or something amidst all this other stuff going on, and you have to have an emergency meeting, then you only have to provide 1 hour notice for that. So just again on the communication issue, some of you may have limited access to your offices right now. You're not allowing people to come in and out as usual. I would just say think about ways you can keep the lines of communication open with the people that you work with all the time. So well drillers, vendors, local authorities, obviously the public. And some ways you can do that is, ensure as much information as possible is on your website. Forms or anything else that someone might normally have to come in and pick up, make those available online. And also make sure your website is updated. That should be happening anyway, regardless of a pandemic, but especially now. Don't unnecessarily frustrate people by not having information available and correct information. Also, you can allow people to make appointments. If there's something they absolutely have to talk to you about in person, just say, let's set up a time and we can be safe and social distance and all of that. And respond to emails and phone calls in a timely fashion. If you're working remotely, especially, sometimes you can get out of that office groove and lose track of emails and such. And not that I've ever done that, but I'm just saying some of you may have. And anyway, it's real frustrating. I had a situation where I was trying to get a hold of someone at a state agency recently, and I couldn't. They're all working remotely, so I called some number and they had to get this guy's email, and he didn't reply for several days, and it just kind of felt like because they were remote, they were out of touch. And so definitely don't want to go that direction. And so just keep people informed. If you use social media, ramp it up now. Just even sending out just cheerful messages would be nice at this point for people to see that you care and you're still in business and you want to help them with whatever they need to have done at the district. Technical difficulties. You may, if you've been doing this for a while now, the virtual meetings, you have probably already encountered this, but if they continue, I would just say have a contingency plan. So, before you have your next meeting, decide what are we going to do if something goes wrong with the meeting? And that kind of helps you be prepared. Also, remember that the hearing can be continued or rescheduled. So you don't want to keep persisting with a meeting that's going badly, where people can't hear, or there's audio or video issues, just go ahead and continue or reschedule it. And, you know, also the meeting chair can just suspend the meeting for a while, you know, you attempt to fix it. I wouldn't do that for too long, but if it's a 5-minute issue, then, you know, just suspend it for a minute. Make sure that your meetings, though, reflect anytime you disconnect. Your meeting minutes should reflect your disconnections and your reconnections. And then finally, the Department of Information Resources says on their website that they have a support line that you can call if you have technical issues. Hopefully they're responsive, but if you have ongoing issues, I would contact them. They have also published a how to do virtual meeting guide on their website. I have a slide at the end of the presentation that will show you their information, but definitely use that resource if you need to. In terms of like what platform you're using, by now you've probably picked the one that works best for you, but they all have their pros and cons. But just some best practices, I would say, are definitely use a unique ID and for your meeting, and require a password so you don't have crazy things happening during your meeting that you don't want to happen. Also, the ability to mute and unmute attendees is helpful to avoid people talking over each other and things like that. Use a tech moderator, or just have one point person, maybe somebody on your staff that gets all this stuff, to be the person that if something goes wrong during the meeting, that's the person that will step in and not have everyone sitting there kind of fumbling and looking at each other wondering what to do. Maybe you can hire an 18-year-old kid in your community to come in and help with these issues when they arise. You can also read some ground rules, when you start your meeting, and just say, this is how we're going to facilitate the meeting. Each person needs to introduce themselves before they speak. Just some simple things so people will know what to expect. Definitely do not deliberate or take any action while a meeting is paused. This happened in a Texas city recently at a city council meeting. They were having technical issues. They paused the meeting and they voted on something, and that did not go well for them. And so make sure that you're not doing that while your meeting is suspended. And finally, I would just say, don't accidentally keep the audio and video going when you're having a closed executive session. Make sure that you have shut everything down while that's happening. Okay, so moving on to some Public Information Act changes that have happened. During the last session, Senate Bill 494 added a section to the government code that says a governmental body that's impacted by a catastrophe or a disaster can suspend applicability of the act for up to 14 days, calendar days. So, normally you have up to 10 business days to respond to a Public Information Act request. So this gives you a little more time, and definitely, this pandemic would qualify as a catastrophe. So how does this apply during COVID? Well, there's some guidance from the Office of the Attorney General that basically says this suspension process, which is in the Public Information Act, is where a governmental body is open for business, but they determine, well, there's a catastrophe, and so it's interfered with our ability to comply with the act. This section would not apply if you were just completely closed for business, then you don't have to ask for a suspension, obviously. One thing to note is you have to provide notice to the Attorney General on their prescribed form. So if you determine we're affected by this, we need a suspension, you have to provide notice. They have a form on their website, and it doesn't require their approval. It just requires you to inform them. So how long is the suspension period? Well, the initial suspension is not longer than 7 consecutive days. Okay, so when you're looking at all of this stuff, if you get a request, just make sure that you're paying attention to when it says calendar days or business days or consecutive days, and that you're keeping in mind, you know, when you're counting what those specifications are. You can ask for a one-time extension for an additional 7 days. You have to provide updated notice to the Attorney General if you do that. So one thing I'd like to mention is this initial suspension period. It can start up to 2 days before you provide notice to the AG, but it can't be longer than 7 consecutive days. So you can't try to eke out more days by delaying your notice to the Attorney General. So keep that in mind. Also, total suspension period, no longer than 14 calendar days. If you get a Public Information Act request during your suspension period, then the day that you received that request is shifted to the first business day after the suspension period ends. So if you get a request on a Tuesday and you're in a suspension period and your suspension period ends on Thursday, then you're going to consider the first day that you received that request as Friday, assuming it's a business day. So you kind of just really have to be careful with this, that you don't miss the deadline as you count these days. Calculating business days, this is something the AG has offered guidance on for a while. Holidays aren't business days, weekends, skeleton crew days. If your offices are closed due to COVID and you can't access records, or even if you have staff working remotely but they can't access records, that's not considered a business day, so that wouldn't count against you. So that's a good reminder. The governmental body, so you have to provide notice to the public of the suspension in a readily accessible place. So definitely your website, and then anywhere you're required to post notice under the Open Meetings Act. So that notice is required to be up as long as you're in a suspension period. And then the AG's office posts notice of all these catastrophe notices that they receive on their website for a year. I don't really know why that is, but I went on their website and there are pages and pages of these catastrophe notices. So if you want to look at that and see who's taking advantage of this, you can, and many of you may have already done that. So with all of these temporary suspensions and such, what's going to happen in the next legislative session? Well, who knows? I mean, there's just going to be a lot of things going on, and I have heard that some representatives have noticed a lack of urgency from some governmental entities in responding to Public Information Act requests. Now, mainly this has been in the context of getting information from places like nursing homes about COVID. So there may be a push in January when the session reconvenes to close some loopholes that have been identified, and those may be broader than just COVID-related situations. So we'll definitely be watching that to see what happens. There was an AG opinion issued in July addressing the Health and Human Services Commission. They had refused to release some information on nursing homes. I think it was just the nursing home names and locations where COVID outbreaks were happening, and they did not want to release that. And the AG said, yes, you are going to release that. They required them to release the bulk of that information. All right, so shifting to just some employment law changes during COVID. Again, you have probably dealt with these already, but these are federal regulations. The Families First Coronavirus Response Act, or FFCRA, was passed in March, and it's enforced by the Department of Labor. and it's currently effective through December 31st. Now, when this was first passed, that seemed like a long time ago. Well, we're getting closer and closer to December, and so this could be extended, who knows. But it does apply to all private employers with less than 500 employees and all public employers. There are some exceptions for emergency responders that might be considered essential employees if they provide essential services like water and things that are people's necessities. So it could affect some of your personnel. So keep that in mind if you haven't already looked at that. But the FFCRA basically has provided two different leaves that people might be eligible for. The first is emergency paid sick leave, and for that there are 6 qualifying COVID-related reasons. There's so much information on this stuff. I am only hitting the very highlights, but 6 reasons. It provides 80 hours of paid sick leave for full-time employees, and then for part-timers, it's based on how much they've worked for the last 2 weeks, an average. The amount paid depends on the reason for the leave, and it's subject to daily caps. And you cannot require employees to use other leave first in this situation. They can choose to, but if they have saved up other sick leave or vacation or PTO, whatever, you can't make them use that first. And then I would just mention that there's really minimal evidence of the need for this leave. They basically just have to say, yeah, Dr. So-and-so said, I can't come to work. Or obviously if there's a quarantine or something, then they're eligible for it. So you can't require, doctor medical records and things like that. I would just point out that this is based on if they're unable to work in person or to telework. So if somebody's at home because of a local order or quarantine order, and they can still work remotely, then they don't qualify for this leave. So keep that in mind. The other leave that's provided under this act is emergency family and medical leave. This provides up to 12 weeks off if the person can't work, again, in person or remotely, because they have to basically take care of a child under 18, like if their school or their daycare has closed. So the employer is not required to pay the first 10 days because, the person could take the emergency sick leave for that first 10 days. But they are required to pay 2/3 after that, and that's subject to a cap also. And then emergency FMLA is reduced by any other FMLA taken during a 12-month period. So if you have an employee who takes 3 weeks of the emergency FMLA, and then they're eligible for just normal FMLA, they can only take nine more weeks of that. It's not doubling up on the FMLA. So I would just say, even if you don't have employees who would normally be eligible for regular FMLA, they're going to be eligible for this unless they fall under very few exceptions. And the key really to these requirements is just to make sure that you're treating similarly situated employees the same. You do need to obviously analyze each request carefully. There may be some people that, based on their job or different situations, it's going to be different, but just watch out for making special deals with people. If you're going to do one thing for one employee and they're in the exact same situation as someone else, then treat them the same. For non-compliance with this act, you could be subject to back pay, liquidated damages, attorney's fees, and civil penalties. So you want to make sure that you're documenting everything and just keeping real careful record of what you're doing. Finally, on this emergency medical leave, the job is generally protected when the person returns, with some very few exceptions. And small businesses with less than 50 employees can claim an exemption if the business is jeopardized. So, but that exemption only applies to if a person's requesting off to take care of a child because their school's closed. So you can't be exempt from providing emergency paid sick leave, but if you have several employees whose children, their schools are closed, and they have to stay home, you could be eligible for this exemption. You just have to document some things, and that's all provided on the DOL's website. Finally, I'll just say notice requirements. There are posters on the DOL website that you are required to post about the employee rights under this act. You've got to put it in a conspicuous place in your office, or if you're not in your office, you can just post it online, send it to employees, but just make sure that they have that and know what their rights are. Finally, I just wanted to provide some resources to you that you can look at later. For Open Meetings Act questions, the Attorney General's webpage is really good with explaining all of the suspensions. For the video conferencing issues I mentioned earlier, Department of Information Resources is great. Again, the Attorney General's office for any questions about the Public Information Act suspension. And finally, for FFCRA, the Texas Workforce Commission has some really great information on their website, and the Department of Labor. I mean, they've got pages and pages of FAQs, and they're really helpful to talk about specific situations. So I would encourage y'all to look at some of those if you're dealing with these issues, and there's a lot of resources out there because they can be pretty complicated. And that's it. I hope that's very helpful, and I'm happy to answer any questions that you have.
Thank you so much, Jennifer. That's amazing how the landscape has changed with all of this stuff, and how much material there is and considerations that you know, public entities like GCDs need to be thinking about. We have had some questions come in, and we do have a few minutes, so I'd love to have you take those on if you don't mind. The first one is on the Open Meetings Act suspensions. Have you navigated the lack of uniform suspensions that might be applied in a multi-county GCD?
No, I haven't. So say that question again.
How have you navigated the lack of uniform suspension applied to multi-county districts?
Okay. So people are just doing it differently. Is that the issue?
I believe so, yeah.
Okay. Yeah, I guess I don't have a good answer to that question off the top of my head. I'd have to think about how that would play out. I'm happy to, whoever asked that question, if they'll give me their contact information, I'll try to address it, but I don't know off the top of my head.
Okay, no worries. I can absolutely do that. Another one came in. What if a member of the public does not register for a virtual meeting in advance? Can you really prohibit them, or should you really maybe prohibit them from making public comments?
I definitely would not prohibit them. I mean, especially right now, you know, under normal circumstances, like if you were having in-person meetings and your rules require people to register, then, you know, maybe not. But right in these days, I would just be as flexible as possible. And if people aren't doing it exactly the right way, I would just let it go and let them speak, and you know, ask them to register at some point, you know, get their information. But if they don't do it ahead of time, I wouldn't push that point.
And then another one came in that had to do with, what if you hold a meeting, you don't record it, but you don't realize that you don't record it, and you complete the meeting and have done everything? Oops.
Oops. Yeah. Well, I don't know what you would do to redress that other than, you know, hopefully you still have really good meeting notes. If somebody requests a recording of it and you don't have it, I think all you could do is provide them with the minutes and hope that they don't make a big stink about it.
You wouldn't have to go back and hold that meeting again for any decisions that were made during it?
Yeah, I mean, I don't know that is required, but I would just make it very public, you know, all of the decisions that were made.
Mhm.
And I mean, I guess you could do like a reenactment of the meeting. I've never heard of anyone doing that. If someone has done that, then chime in. But
I'm not aware.
I don't.
Okay, great. And then there was one other one that came in, and it had to do with committee meetings, and I'm not sure exactly what kind of committee they were referring to, but whether or not committee meetings are need to comply with the changes to the Open Meetings Act. So maybe that's
Well,
committee of a district.
say that last part again.
Perhaps that's like committees within a district, like if they were to form, you know, a
Like personnel.
Mhm.
Yeah. Yeah, I mean, those aren't subject to any of this because they're not required to have a quorum, and they're not making decisions as a full body. So that's committee meetings are not under these requirements.
Right. Okay. And I just to get clarification that was the, you know, if it's not making the ultimate decision for the district, but rather recommending action, so then it wouldn't be subject.
Right. Right.
Wonderful. Well, that's all the questions we have, but this was obviously one that got people thinking and wondering about how they're making sure they're carrying out business appropriately under these changed circumstances. Jennifer, this was a great presentation. Really appreciate you being here. Thank you.
Thank you.